Hey guys, it's Debbie, and I'm thinking this is going to be the last that we hear of Sarah Boone, except for the sentencing. But she has filed another motion, and this motion is for a new trial. I'm not surprised. I think this is kind of par for the course. I think that they all do this pretty much. So we're going to look at the motion for a new trial. State of Florida v. Sarah Boone. Defendant's motion for new trial. Comes now the defendant, Sarah Boone, by and through counsel and pursuant to Rule 3.600 Florida Rules of Criminal Procedure, files this motion for new trial, stating in support thereof the following. 1. The defendant was found guilty as charged of second-degree murder on October 25th, 2024. 2. The instant motion is timely filed pursuant to Rule 3.600. 3. The defendant asserts that she is entitled to a new trial under Rule 3.600 on the following grounds. 1. The court erred in ruling that the defendant was not entitled to court-appointed counsel, which I don't see how that matters now because she had counsel. 2. The court erred in denying undersigned counsel's multiple motions for continuance. 3. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. 4. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. And 5. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Law Argument 1. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7, she had 8, court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. How nice of him. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. Wow, don't hurt yourself patting yourself on the back, buddy. It was apparent to undersigned trial counsel that Miss Boone would be grossly ill prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Well, guess what? It was apparent to me too, and I'm not a lawyer. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. See Bowden v. State and State v. Kelly and progeny. There appear to be 2 exceptions to this precedence. 1, if the defendant physically harms or threatens to harm, rape, battery, etc., his or her counsel. And 2, If the trial court certifies that the defendant will not be incarcerated if found guilty, i.e., a judge trial, should the court determine that the defendant is not entitled to court appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process as well as a defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court appointed counsel. And if the court determines that she waived her right to court appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court appointed counsel. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for a new trial being granted. See Figueroa, Sanabria v. State, and Wilson v. State and progeny. Under controlling precedents, Rule 3.11, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant through counsel moves the court for a new trial. And again, I don't see how this applies because she had counsel. So I don't even know why he's going there. That doesn't make any sense to me at all whatsoever. Argument 2. The court erred in failing to grant defendant's motions for continuance made by undersigned trial counsel. Okay, so let's say that they didn't say, let's say Judge Crane didn't say she had to be pro se. Let's say after, I forgot the lady's name, the lady attorney that she had that quit. Let's say he had given her another court appointed attorney. He wouldn't have got any continuances either. So that wouldn't apply. The first part wouldn't apply at all. So would she have gotten a new trial because of this? Because that wouldn't have applied. Argument 1 wouldn't have applied. So she didn't get a court appointed, but she got a pro bono one. I started to say pro se. Pro bono lawyer. So why is this even in there? And then this, Kranick said no more continuances. Before he even came on the case, he said no more continuances. But now he wants to argue for a new trial because of this. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for a continuance by new counsel. See Perozzo v. State, McKenzie v. State, Jones v. State, and Deal v. State. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Ms. Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records of prior contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, which no one asked him to do, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Miss Boone was entitled to. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. Now, I know he's doing this because he's zealously representing his client. Like, I get that. But the things that he's saying, like, well, she needed representation or she was going to be unprepared because she was going to have to represent herself. And I had to close down my law practice in order to represent her. And I didn't have enough time to represent her fully in the way she needed to be represented. I don't like that he's doing that. Like, that's like, poor me. I couldn't do a good enough job because I didn't have enough time. Nobody asked you to take this case. Like, he's crying, oh, poor me. And I know he's doing it to get her a new trial because she was found guilty. Like, I get that. But I don't like the way he's going about it. Do you know what I mean? Like, he's using his circumstances to get her a new case, or a new trial, which I just don't like it. It's like, it's arrogant. It sounds arrogant to me. Like, I don't know. I don't know how to explain it. I just don't like the way he's doing it. It feels like he's, crying, poor me. I just couldn't do it because I didn't have enough time and I didn't have the right resources and blah blah blah, and I let her down but it wasn't my fault, but that's not what happened. That's not at all what happened. She was going to be found guilty no matter what. I mean, she was the only one there. She zipped him in the suitcase. She said she did it. So, I don't know. Okay, I'm going to keep reading. Argument 3. The court erred when it denied a motion for a new trial due to an emotional outburst in the presence of the jury. Now, this one upsets me as well because number one, this outburst was not a big outburst. I missed it. If y'all watched the trial with me, I missed it. I was like, wait, what? What happened? I didn't hear anything. Um, and yeah, the family watched a video of their loved one possibly taking his last breath, begging this woman to let him out of this suitcase because he couldn't breathe. Yeah, I'd have an outburst too. I don't think the outburst swayed the jury's decision one way or another. In fact, I think they had probably pretty much already made up their minds at that time. They were only out for an hour and a half. I don't think it took them long to make a decision once they got back there. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of a court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. See Nabergel v. State, Smith v. State, and Colin v. State. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. Argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. This is a gray area for me because I didn't 100% understand what the big deal was, but they had a whole hearing in the middle of the trial about this. And I thought they had, I know they didn't fix it to his satisfaction, but the judge ruled on it. So now he's trying to get the judge's ruling during the trial overturned. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert, Dr. Tanya Werner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Mutri v. Bethune-Cookman University. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Hunt v. State. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. Boone v. State. This testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. Lee County v. Barnett Banks. Argument 5. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as rebuttal. Wherefore, premises considered, the defendant seeks the relief sought herein, as well as any other relief to which she may be entitled. The defendant requests a hearing in this matter. So, if there is a hearing on this, I will cover it if I am able to, and there's not a conflict. I'm going to be doing the Lincoln Riley murder trial on the 18th. But of course, if there's a hearing, I won't do it. If it interferes with the trial, I won't do it live, but I will do it. So, subscribe, hit the bell for notifications, and like this video. And remember, be kind to people, love your family, and Jesus loves you. And I will see you guys in the next one. Bye.